Hey everybody, it's Andy, and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video, I'm going to go over how you make a will in California. So just to be very clear, when I talk about wills, I'm referring to basically the document that people create when they get to the end of their life, when they think they're about to pass away. And in the document, or in their will, they talk about who they want to leave stuff to, how much to leave each person, etc. So this video is going to go over how you generally create a document like that in California. This is actually the first video in a series of two where I go over the validity of wills generally. This video is going to go over how to create a will in California. The second video, which I'm going to play a little bit of actually right over here, I'll link it down in the description for you also. But in the second video, I go over how California law determines whether or not a will is valid or not. So if you're watching this video, it might be worth it, I think, to watch this video as well as this one, like the one that I'll link down below, to get the full picture of how to create a will in California that is going to be correct. So I think, well, in general this is true, but I think in particular it's true for wills. Whenever you write a document, like a letter, a contract, an email or something, it's important to get it right, but the thing is, at the end of the day, you will hopefully be around to clarify any sort of misunderstanding, to explain things if it weren't clear. A will is obviously going to be very different because if you don't make your will clear, for instance, or you don't comply with what you're supposed to do in order to make a will valid, you will basically not be able to fix it because you're obviously deceased. And the kind of ramifications of that generally will be left to your heirs, your friends, your family, your children, etc. to deal with. So a will in particular is a document that you definitely want to get correct. Because if you don't, then the stuff that you want to leave to your spouse, your children, etc. Possibly might not go to your spouse or your children. So a will, basically is something that you definitely want to get correct, and do as much research as you can, hire a lawyer, etc., whatever works for you. So all of that said then, this video is going to go over two sections of the California Probate Code, and they are going to be section 6110 as well as section 6111. 6110 is going to be the more heavily used section, I think. 6111 is much shorter. Actually, they're both short. 6110 is like that. 6111 I think is a little bit shorter. But 6111 is not going to be used probably as frequently, I guess, in my experience, but your experience might be different. So anyway, all of that said, then let's go ahead and delve into section 6110. So 6110 has several criteria that a will has to meet in order to be recognized as valid in California. Number one is that the will has to be in writing. 6111 goes over handwritten wills, but when I say in writing, it could be handwritten, it could be typed, etc. But basically, it cannot be oral. An oral will is called, just in case you're interested, a nuncupative will. California does not recognize those, but other states do recognize them for whatever reason. But California does not. So anyway, the first kind of criteria is that the will in question has to be in writing. Number two is that the will has to be signed by either the testator, the testator's conservator, or by somebody in the testator's presence at the testator's direction. What does all that mean? So first things first, the testator is the person who is creating the will. So the thing is, if you're creating a will for yourself, you're the testator. If you're helping your mom or your dad or whoever create a will, they are the testator. So the testator is going to be the person who is making the will. So the will, the writing in question, has to be signed by the testator themselves, by the testator's conservator, if the testator has been conserved, or by somebody acting in the testator's presence and at the testator's direction. So what that last one means basically is, imagine somebody who's trying to make a will who is going to be mentally present, like mentally they're still fine, but due to perhaps old age or due to other kind of medical problems, they are not physically able to pick up a pen and sign their name anymore. So what they basically do, hopefully if they still can, is to kind of tell somebody, hey, point to them, they point to somebody and say, hey, this is my will, I need you to sign this for me, do it in front of me, etc. That's what that third criteria basically means. So talking about wills, I guess, is a little bit strange because you do have to account for the fact that, you know, the person who's making the will might not be physically able to sign their name, you know, in the way that they otherwise would. So a lot of times, you know, when you're talking about testators, you're talking about at the direction of the testator, acknowledgement by the testator, etc. So anyway, back to the criteria. Number 1 has to be in writing. Number 2, it has to be signed. So number 3, I actually get a lot of questions about, and it's actually the witness requirement. So California Probate Code section 6110 says there has to be at least 2 witnesses to the signing that also sign their names to the will. And the witnesses actually have very specific criteria. So number 1, they actually have to witness either the testator signing the will themselves or the testator acknowledging to the witnesses that this is my signature. So again, think back to somebody who is elderly, you know, incapable of signing their name, but if they can somehow communicate that, hey, you know, this is my signature on this will, that would be sufficient. So the witnesses have to witness witness all of this stuff happening during the testator's life, obviously, if they, if the testator has to sign or if the testator has to acknowledge. The last part about witnesses is that the witnesses also have to understand that what they're signing off on is a will, and it's not a permission slip for a child, it's not a pizza delivery order, it is a will, and it's significant because, you know, it's the testator's last will and testament. So that's what 6110 basically goes over. 6111, it basically says that if a will, for whatever reason, does not meet any of the criteria that I just described, but the will is handwritten in the testator's own handwriting, that's fine also. That's actually called a holographic will, and California will recognize those just fine. Probate Code section 6112, I'm not going to go over, but it kind of presents in a nutshell what happens if, you know, there's a dispute about the will, what happens if one of the witnesses falls away because they're declared invalid for some reason. So 6112 I'm not going to go over. If you want to get in touch, and I can, you know, try to help you with 6112 if you like. But 6112 I'm not going to go over in this video because problems about how to argue and stuff, those are very, very specific. I can't, you know, kind of tell the camera right now how you should do your particular situation. So anyway, I guess hopefully all of that made sense. The second video where I go over validity of wills, that's actually Probate Code section 6113. That one's actually not terribly complicated. That last criteria I think is going to be kind of a mouthful to describe. But hopefully, I got it out, I guess. We'll see. So anyway, but in terms of how to make a will, Probate Code section 6110 and California Probate Code section 6111. So anyway, I'm going to link both of those down in the description for you, so go ahead and take a look at that. And go ahead and comment, share, like, subscribe, you know, all that kind of social media-y stuff. And I will talk to you guys next time. Thanks.